And I don't refresh my memory on how this works.
Sure. So in the rules of disclosure, the 193.7 disclosures, plaintiffs have to list
disclosure obtained under section 4105B. That's all medical records.
This is one of the most incredible things I've ever...
What happens right now, Chairman Perry, is I would have the opportunity to go to the judge and say, hey, judge, they have subpoenaed this lady's records from UTMB. When she was in college, she got a sexually transmitted disease. And she's now 35 years old. She has 2 kids. Her husband doesn't know. Nobody knows. They get to get the records. I'm talking about what's in the bill, not what they're talking about. I'm talking about this. And it says it's admissible by either party into evidence, relevant or not, right? And as it is today, they can discover all this stuff they're talking about. But I get the chance to try to go to the judge and let the judge review in camera, which means in the judge's chamber, he looks at it before anybody else looks at it. So I can point out to him the things that are in the records which are not relevant, or their relevancy is outweighed by the prejudicial effect. And that, under this bill, is gone.
Dean Zaffarini has questions, and then we'll go to the author. Dean?
Thank you, Mr. Chairman. Mr. Island, what would you say to those who argue that this bill does not preclude a plaintiff from recovering the full measure of compensatory damages or punitive damages for any injury caused by the gross negligence of an employer or an employee?
This bill doesn't impact punitive damages at all. So I would agree that this
You'd
bill
agree with
doesn't
that?
impact punitive damages.
And what about the compensatory damages?
Yeah, it impacts compensatory damage in multiple ways. And one which hasn't been talked about is there is a requirement today that a jury verdict on all issues has to be supported by a 10-2 verdict, okay? This bill says some of it can be supported by 10-2, but non-economic pain and suffering has to be unanimous, right? So that means if you get a 10-2 verdict on the rest of your case, on liability, 10-2, on lost wages, 10-2, on future lost wages, 10-2, past medical, 10-2, pain and suffering, 10-2. You get 0 pain and suffering. 0 under this bill. That's one place where it caps damages, because it changes the requirement of what the jury has to find.
And yet there are those who say that this bill does not cap any damages and would not set any medical billing rates. What would you say to them?
I would say the whole purpose of this bill, as shown by the materials that the proponents of the bill sent out last week, is to cap and limit damages in civil cases.
Are there more than one section of this bill that you believe raises constitutionality questions?
Yes, and we've talked about it, but the remediature section definitely raises constitutionality questions.
Any other part?
Not that comes to mind.
Okay, thank you.
Well, I can tell you this. You know, if you want to cap non-economic damages, we did it in 2003, and we went to the people of the state of Texas and let them vote on it. But in order to do that, you got to get 2/3 in the Senate and 2/3 of the House. And I think the proponents of this bill know that they can't get 2/3 of the Senate and 2/3 of the House to take it to the people to let them vote. That bill in 2003 also said, if you want to cap any other damages other than doctors, med mal, you got to get 3/5 in the House and the Senate. And I think the proponents of this bill know they can't get 3/5 of the House and the Senate to cap damages. And so they've come up with this other scheme to try to wiggle around and cap damages in a non-straightforward method, which is like all the stuff that we've talked about today. They change it here, they change it there, and then it all comes together to cap your damages.
Thank you so
Or
much.
eliminate them in a
Thank you so
10-2
much.
verdict.
Ma'am, you support the bill?
I do.
Is there any part of this bill that you believe needs improvement, or do you support the bill as is?
Well, I think there's always room for improvement, Senator. I think that the remediator section could provide additional clarity because it keeps being said over and over that this is some sort of new issue. But remediator has been on the books since the signing of the Constitution in Texas. It is, as my colleagues here to my right have stated today, it is used already in Texas on a regular basis. And if that's not clear, that this is just another remedy that's being put in place when a judge who has sat through the entire jury trial and also heard all of the evidence and is a member of the bar believes that the evidence is not in, that the jury verdict for damages is not in line with the evidence that was heard. It's just a remedy to be able to make sure that that judge looks at it, signs off on it, sends it back if he wants to send it back or she wants to send it back. And so I think that because of the amount of confusion on this very clear topic, that maybe that section could use some work.
Thank you. Thank you very much. Do any of you believe that there are provisions of this bill that would impact the court's backlog?
Absolutely.
In what way?
I think that it's going to reduce the number of times I run to the courthouse on discovery motions having to do with medical billing. It should, if it's used properly and applied properly, it should reduce the number of witnesses at trial. If I will tell you in practice that when a plaintiff uses their health insurance, the amount of damages that was billed, it's reasonable. I can't go get a witness to say that that's an unreasonable amount, that amount wasn't paid or incurred, which is the Haygood v. Escobedo standard. We accept that as true. That provider doesn't have to show up, and I'm not going to argue it, and I'm not going to ask the jury to consider whether that was a reasonable amount of damages. That was a reasonable amount of damages for the treatment. So it absolutely reduces jury time. It absolutely reduces my discovery motion practice.
Is there any possibility it could have, any provisions of this bill could have a negative impact on the backlog?
Yes.
In
Yeah,
what
and I
way?
know that we have a former judge who's going to come and give you specific examples for that. So I'll punt to let him testify anew.
All right, thank you. Yes, ma'am?
I would just add that it will also facilitate more settlements. I do believe that the insurance industry is fair and reasonable, and the cases that go all the way to trial are only because we can't get to a fair and reasonable, middle ground here as to what is going to compensate that plaintiff, right? Not, make this a windfall for them or, create generational wealth, but just compensate them. So yes, if we have reasonable medical bills, then we are looking at mediations that will settle cases and get them off the docket left and right.
I disagree with that completely. Because what's going to happen if you pass this bill the way it is, every small town and hometown lawyer and small firms are going to send all their cases to the big boys in Houston, Dallas, San Antonio, because they're not going to be able to meet all the provisions of this bill and all the new requirements they're going to have. So if you want to hurt the Walmartization, of lawyers and small firm lawyers, this bill is going to send everything to the big boys.
So, Mr. Island, if this bill passes, who are the winners and who are the losers?
Well, the losers are your constituents that are injured Texas. We're talking about every single personal injury case from now on, right? Catastrophically injured people, SORNAC car wrecks. All of this is going to change the practice of law completely.
Who are the winners?
The winners are going to be insurance companies. And I think she's right. A lot of people will settle for a whole lot less because they're not going to be able to jump through all the hoops and meet all the conditions in this bill. And people are going to say, I don't want all of my medical records from my history at this hospital system to be put into evidence. So I'll take whatever you can get me.
May I respond? So in the example that I was speaking about during my testimony, I was talking about this particular medical provider who charges a very large amount and then always takes significantly less. Well, let's just say that the bill says $100,000, just for easy numbers. The bill is $100,000, but she will accept $40,000. What if the plaintiff had just used their medical insurance? If the plaintiff had just used their medical insurance and the medical insurance had paid for that treatment, then the medical insurance would have paid for that treatment and they would be out what? A copay and maybe their out-of-pocket expenses for the year, which is obviously, it varies. If they don't use their medical insurance, then after the jury awards makes their award or we've settled the case, they now subtract $40,000 to pay back that doctor. They have effectively paid significantly more for that treatment, that it came right out of their damage award, right out of their settlement, than they would have had they used their health insurance. So that may not be the fact in absolutely every case, but it will be the fact in every case where this particular provider is involved, because the treatment is overbilled every single time.
Thank you all. Thank you, Mr. Chairman.
Thank you, Dean. Senator Schwartz, you're recognized.
Yes, just two questions, and I appreciate the discussion and the questions of the my fellow colleagues. This question is to Ms. Aker or Ms. Casey. There was a contention made that there was a constitutional violation in Section 8 of the bill regarding the right to a jury trial being preserved. Would one of y'all like to opine on that contention made by Ms. Temez?
I'm glad you asked that because I actually made a note that the right to a jury trial is the one thing that my opponents and I completely agree upon. And what we're seeking here is truth, that the whole jury system is meant to get to the truth of the matter, right? And they should be the arbiters of truth and award a fair and reasonable amount to compensate a plaintiff. What's happening is anything but. And what the plaintiff's bar is trying to do here, and why I use the term fraud, even though it's a strong word, is because they are presenting to the jury 10 times inflated meds, right? Even assuming that the care was necessary, which is a whole nother issue, right? But just the amount of those bills is not the reasonable customary amount. It's not what that provider is expecting to be paid. There are literally bills submitted to plaintiffs' attorneys that are called on the record and off the record. And when I saw that, if that's not fraud, I don't know what is. Because the on the record is what they're supposed to send to the defense attorney and show to the jury and get compensated for by that jury. The off the record is what they'll really take. And it's as disparate as 180 grand on the one hand and 37,000 on the other. That's a big difference. And that's what the jury is now, and this is why we're having these runaway verdicts, because it's not a fair amount to compensate that plaintiff. It is an artificially inflated number that now becomes a windfall, right? And Senator Zaffirini, you asked who suffers from, the plaintiffs themselves suffer. They are literally forced into getting a lot of treatment that they do not want. They really don't want these back surgeries, but they are told that the value of their case is incumbent upon them getting at least, it's worth X without a surgical recommendation. It's worth Y with the surgical recommendation, and it's worth Z if you go get that surgery. And these plaintiffs' attorneys are graded on how frequently their clients go to the doctor. Clients will call basically in tears, like, I don't really want this surgery and I know you're gonna be mad at me. They are then forced to sign a document from the plaintiff's attorney that says, I know my case is worth less, but I just really don't want this surgery. That is shameful. They don't want the surgeries, they don't need them. And the doctors who should be making these decisions with their patients as to what's best for them should have the sole purview of what's going on in that treatment, right? It shouldn't be a matter for the lawyers to determine, yes, this client needs surgery, go get surgery, because that's for them. Should have the sole purview of what's going on in that treatment, right? It shouldn't be
We're back live.
a matter for the lawyers
This
to
lady
determine, yes,
is
this
ridiculous.
client needs surgery, go get surgery.
My commentary
because
is
it'll
coming
up the
soon,
value of
my
case.
friends.
We'll get more money. Ones that are going to be affected by what we're trying to do here. They'll probably have more money to settle their cases if the docket wasn't, absolutely congested with this, 90% of the cases that are back and neck injuries that were probably pre-existing, and they get overtreated in both the amount and substance of that treatment. That's what this bill is looking to curtail.
Thank you. This evening, I guess now, and this morning, I heard lawyers disparaged and terms such as cheating lawyers. And my question is, do the witnesses like you who use terms like that have data to that effect, or is this anecdotal or opinion? Is this something that's a widespread problem or something that perhaps has happened?
Yes.
But how do we justify using those terms or disparaging plaintiff lawyers?
Well, it's not just a few. I think there were a couple of the big boys, right, who sort of started this, and it became the playbook for every other plaintiff attorney out there. And now every single plaintiff's attorney follows that playbook. And they send their clients out to the usual suspect treaters. These docs are not the ones who are treating, the general population. They pretty much only
literally disparaging lawyers, making up complete bullcrap.
Is there evidence to that effect, or that's what you think? Is that your opinion?
Every single plaintiff's lawyer is making up medical, is what she's testifying to the committee.
Plaintiffs who weren't on the crash report as even being in the vehicle, and minors, including, that then go get the same identical treatment. The same provider,
Listen to this
same
woman.
injuries.
Jesus.
They go.
All right, folks, we are back on the stream. I hope you're joining us. Live reacting here. We literally don't get an opportunity to talk. She's just saying bullshit. With no evidence, nothing to back it up. She's literally just making crap up. It's not every case. It's such a damn lie. Yeah, let us talk. And that is just crap. I mean, she goes on this complete tirade that has no evidence to back it up. She has nothing at all to back up anything she just said. All we know is she's some defense lawyer who's pissed off about a bunch of plaintiffs' lawyers she can't name going and getting treatment they don't want. She's testifying that there are claimants calling her crying, saying that they're having surgery when they won't want to. Never met a client who's done that. Let's keep listening.
Well, what counsel has just stated is exactly why there's jury trials. And good, competent defense lawyers are going to bring up their defenses. But that is why the jury is the sole fact finder of the credibility of the witness, to include doctors, to include any witness to the incident, to include the plaintiff, to include the defendant. And because they are the sole fact finders, and they want to bring up all kinds of evidence that maybe the bill is too high, too low, that, again, remains with the province of the jury, and the judge will answer the questions of fact. But that is exactly why we have jury trials.
Except you're not letting me tell the jury all of the facts. I'm not able to tell them that the treatment was done at the direction of the lawyer. That doesn't come into evidence, and that's one of the things we're asking, is that
that doesn't happen. She's making this up because she's gone to trial and lost.
that absolutely goes to the bias of the witness. And if I'm not allowed to tell the jury that, then that's what I said. We do want to leave this in the hands of the jury. That we can agree. But then let me tell them.
Let's not decide all the facts of the case.
Let me tell them where this doctor, who sent them there, right? Let me tell them how many times that plaintiff's attorney works with that doctor. Let me tell them what that doctor's getting paid and what that doctor will actually take. Why the smoke and mirrors? If they want truth, then let me have the truth.
Let us talk about insurance companies at trial.
Senator Schwartner and then Senator Bardwell. Go ahead.
Thank you again, Mr. Chairman. Ms. Casey, you're trying to explain the system as it currently is regarding an injured individual that seeks through a plaintiff attorney care for their injury. And you said something very pertinent during your initial testimony, that plaintiff attorneys don't really deal with their private doctors or private insurance. One, they can't control them, is I think what you said, but also in private insurance, it figures into the paid or incurred amount. Instead, they look toward affiliated networks of providers to overdiagnose, overbill, overcharge, which figures into the non-economic damages eventually in the final award settlement. Do I have it right there? Is that something, I think the members of the committee need to understand how it truly works. These are not independent doctors that generally are taking these cases. These are affiliated doctors that have a working relationship with plaintiff attorney firms and have a known, quote, expectation of what they are to do when they have an injured worker.
Says who? You have any evidence of that? And when are we going to start talking about lowering premiums? When are we going to start talking about how this lowers premiums? It's just a complete disparagement of the plaintiff's bar, which is their goal all along. Shocker. Mm-hmm. I need to put my headphones in now. We're going to talk about insurance. Let's talk about insurance. Let's bring it on, baby. Let's talk about how much you're putting on the case. Let's talk about the defense experts you hire, how many times you hire them. That's not always coming in. It's not automatically admissible. That's given discretion to the judge. We don't get to talk about any of that, do we? We don't get to talk about all these other plaintiffs that you're alleging to disparaging now in the community. Anybody going to say about the primary care doc that don't want their patients if they've been interacted? Great point by ET here. We saw him earlier on the stream restoring them from the comfort of his home, having in mind. What he's talking about there is that there are doctors that won't treat you if you have been in a personal injury case. They won't touch it. So do we get to talk about that? Do we get to talk about how doctor after doctor rejects our clients when we try to get them treatment through insurance? Of course not.
Relevant and pertinent medical history, the entire medical history, to make it so that is appropriately adjudicated during the case by the finders of fact, the jury, happens. Ms. Aker, am I missing the mark on the provisions of the legislation regarding the disclosure of the medical history? You want to speak to that? I know Mr. Island thinks I am.
You can go ahead.
Or Ms. Casey, either one of you.
No, I think that you stated it right. Certainly my argument that it reduces the amount of litigation during the discovery phase if all of this is just automatically produced. And I would like to say that one of the things that I think that this bill gets very correct is that I don't actually think that 100% of the plaintiff's bar is operating fraudulently. I have a lot of friends in the plaintiff's bar, maybe fewer after today's hearing, but several friends. And
you're going to have a lot less friends. I ain't going to be your friend ever because you straight lied to the legislature. Liar. You just said a liar.
We've discussed and debated this bill quite honestly, and they don't believe that it affects those that are operating above board. This is information that should be provided. These are disclosures that if there's nothing to hide won't be a problem. This is information that should, if it's relevant, you know,
Thanks, y'all, for tuning
I had
in.
my evidence professor, who I loved at the University of Arkansas.
Back here on the tort reform bill, we're hearing from a defense lawyer on her position how this bill must be passed in order to save babies.
About several times. If it's not relevant, it's not admissible. So just because it says that it's admissible under 1801 or one of these 41, Chapter 41 rules doesn't make it actually going.
Great point by ET here. Yeah, you'll be doing divorce cases when none of us are allowed to have a jury trial in personal injury case anymore. So good luck to you.
It's gonna, the above board lawyers are not gonna have any problems with this at all. And it's gonna leave the judge, the gatekeeper of the evidence, and the jury reviewing the evidence. There's nothing in this bill that prevents a plaintiff from getting to a jury. It simply changes the evidence that the jury is allowed to hear. And as I said earlier, I think that our juries, when they are better informed because they have all of the evidence, and not just the pieces that certain lawyers want them to hear, then we're gonna have more fair trials and then more fair judgments, which then will hopefully also reduce the burden on the courts of appeals.
Mr. Island, you know, she's making the contention that the role of discovery is different than the role of admissibility as provided by a judge. You were shaking your head no, according to the rules of evidence that you articulated earlier. Tell me why.
Page 20, lines 1 through 4. This legislation says it is admissible, period. Period. That's what I'm relying upon to make my statements. And I am an above board lawyer, and I still have problems with this bill.
Got that right. I'm an above board lawyer and I got problems with this bill. You're damn right he does. Because he's a real lawyer. He's not one of these defense lawyers doing the bidding of their corporate oligarchs. It's just disgusting.
And there are, right now, the system is set up to discover everything about the back, everything about the history that could be related to the back, but I have a chance to go to the judge and prevent irrelevant and prejudicial information and let the judge decide. Under this bill, as the way it was given to you, that is not possible.
Bills or
And
bills that affect
that's one thing that should be eliminated, or because I don't know that you can fix it either. I mean, if they want all of the medical records from the UTMB health system on me for any injury that I have, and then they get to bill for it. You get 30 years of records. What do you get to do as an insurance lawyer or defense lawyer? You get to bill for it. And then you get to report about it. And then you deal with it. So don't take away the tools that we have right now to prevent irrelevant information from.
That's right. All these defense lawyers are complaining and whining like this lady to the speaker's left while they're making hundreds of thousands of dollars doing it. She's making hundreds of thousands of dollars. Lord knows what bribes she received to come do this testimony, but making hundreds of thousands of dollars to make sure you never get to court and none of your evidence is heard.
From being admissible to the jury.
I always appreciate it when plaintiffs' lawyers create work for me. I have plenty. I do have to keep my time every 6 minutes. It is a painstaking requirement of my job.
Yeah, you have no problem taking 6 minutes to lie.
I guarantee you this bill is not written to increase my minimum billing for the year.
Senator, if I may just add something quickly. So I don't know that this point has been made, but every doctor who treats a victim of an incident or an injury, it subjects himself or herself to discovery. Discovery about their practice, discovery about their billing under Texas Supreme Court rules and law. They also subject themselves to cross-examination. If they are biased, if they are otherwise, their bills are opened up. And cross-examination deposition, cross-examination in trial where they have to defend their bill. And so I just didn't want it to seem that it's a unilateral process, that there isn't defenses and deposition of these doctors who have made the choice to be part of this process.
Thank you, Mr. Chairman.
And thank you, Senator Shortner. Senator Birdwell, you're recognized.
Thank you, Mr. Chairman. I'm going to go return back to some more rudimentary things, if I may. So I want to make sure you're defense counsel.
Yes, sir.
Do you do that of your own accord, or are you of counsel or a partner in a
I'm
law
a
firm?
partner at a defense law firm.
Okay, defense law firm. I assume there's a defense bar as well as a plaintiff's bar. Is that a?
Certainly.
Is it? Okay. You may have touched on it with Senator Perry, and as the conversation's going, I'm trying to. Does the bill enhance your ability in discovery or evidence
Here comes the softball of all softballs.
gathering? Because you mentioned subpoena or go to the court. Does it give you confidence that everything you ask for you're going to get?
That's right. That's what we want. The defense bar should get every single thing they want. Meanwhile, let's undercut the rights of plaintiffs.
I mean, how do you know that if you approach a defense counsel and say, I need X, Y, and Z, you're going to get, you may get X, Y, and Z, but you don't know that AA, double B, and double C are out there. So what's your confidence level that you'll get all the material that is relevant to the defense of your client?
I understand the question, and what I understand the question to be is that when I request discovery through one of the processes, we call them interrogatories, request for production, disclosures, how do I know that I'm getting 100% of the information that I'm asking for? And the answer.
What about us? What about the plaintiffs? Do we ever get information that we ask for? No. We're the ones who always have to follow the compels. We're the ones who are not rewarded for hiding discovery. The defense bar is. The defense bar is rewarded for hiding relevant evidence so they can make more money, because the more I fight for relevant evidence, the more money they make. We don't get to know what their evidence is. They never turn it over unless they're forced to.
Answer to you is that the bar license, the oath that we all took. We expect that the lawyers on the other side are living up to their oath, as I'm going to live up to my oath, and we are all going to sign those pieces of paper with our name and bar number, and that means something.
Yeah, great question here by CJ. Is this really going to help, given that all plaintiffs' lawyers are liars? Exactly. Hopefully that was sarcastic, but that's the real question. The question is, all plaintiffs' lawyers are liars. How do you know they're going to turn everything over? They'll just keep lying.
Something to most
That's how I have my bar license. That's how I've never been sanctioned, is by constantly lying.
of us. I think that the problem is that it means less to some, and we are slowly discovering that through the other discovery processes, and the very bad actors have really spoiled it for the bunch. And have caused major problems leading to these nuclear verdicts that we're talking about, and then social inflation, which leads to more nuclear verdicts. And so I do believe that the way that this bill.
We just say things. Social inflation, nuclear verdicts. None of those are in the bill. The social inflation topic is, you'll see this on Instagram, because TLR is putting forth a $7 to $10 million ad campaign in support of this bill, that the tort system is causing social inflations, that the costs of tort lawsuits have been passed down to the consumer somehow. I can show you the real study that uses to support this, and raises costs for $4,000 a year to every single household in America. If you go look at the actual study, you'll see it's based on 100% pure hypotheticals. There's no data to back any of this up. But again, another talking point from the insurance company, who, because she keeps repeating these talking points over and over again, you can tell that she is a shill for one of these corporate oligarchs.
Works. It will, but actually by codifying any rule or common law standard, something that's just, written down in an opinion that's been that's always subject to interpretation, then we're going a step further to ensure that there's teeth, essentially, that there's recourse. So I do think that it helps.
If the entity that has the records is a governmental entity, does that change your opinion of the bill? I mean,
It changes.
I'll just tell you, if you have to
how
go,
long it's gonna-
if you have to go subpoena, like if you were my defense,
Sure.
or if I were, I guess, in opposition, but if you have to go to DOD, Department of Veterans Affairs, and some of the other places, I got medical records, does this bill affect your ability to go to non-private but governmental healthcare-based entities? Or is that just a bigger inconvenience factor, but you can still do it?
It's a bigger inconvenience factor because, no offense, but asking the government for much is a slow process. It's a slow
None taken.
Okay.
None taken.
But other than that, no, it shouldn't actually differentiate between the two.
Okay. Thank you, ma'am. Thank you, Mr. Chairman.
Senator, if I may follow up. In your area, if somebody is taken to Baylor Scott and White, and the defense orders the records from Baylor Scott and White, Baylor Scott and White will give them all the records they have of that individual, right? And if they don't, that's Baylor Scott and White's issue, not the plaintiff.
All right, we're going to pause it here. I'm going to skip forward a little bit, try to get closer to the live testimony if we can.
If I don't control what object not related,
I mean, the committee doesn't need to hear my baggage, but that's an immense list. So how does she know that your client has given every, I had this over here and this over here and this over here and that. How do you know that what your client provides you is comprehensive for your needs and for hers?
that's not changed by this bill, right? I provide them, my client tells me where all they've had care related to this accident.
And those records are ordered. Many times we'll enter into an agreement, because if I have a client who has a broken ankle, but they want to discover the gastroenterology where they maybe remove the gallbladder, right? Then we have to create what's called a privilege log based on physician-patient privilege, give them that privilege log, and they can still order us to have the judge review those in camera. And if the judge reviews them and said the gallbladder is not related to the ankle, that's how that works.
Senator Tina Hosta, you're recognized.
Thank you, Mr. Chairman.
I love that the bill doesn't require the defense to do anything. We talked about this earlier, that there's no new obligations for the defense to be truthful during discovery. It's just made up fantasy land that plaintiffs' lawyers and their clients are just completely, constantly lying about medical treatment, medical bills, records that don't exist.
Heard last panel, a lot of discussion this panel regarding, and I just want to make absolutely sure I'm hearing this right. So it was alleged or said that it's common practice for plaintiffs' attorneys to actually require or suggest that their clients use a different medical provider instead of using their own in-network medical professionals, that they utilize those that are suggested of the plaintiff's attorneys. I just want an absolute clarity. Is that a common practice? Do you actually do that? When somebody comes to make a claim, you say, go use these people that we have here?
I don't. There are.
Well, is it a common practice for plaintiffs' attorneys to do that?
I don't know if it's common, but apparently they've raised the issue that some people do.
But to your knowledge, do you see that a lot of, you represent a lot of Texas trial attorneys. Do you see that practice being utilized? Lawyers
will refer their clients to doctors that will see them on a letter of protection especially if they don't have health insurance, right? Number one. Number two,
you listed a couple of reasons why they might, but just in general, I just want to understand it is a common thing.
You can't say in general. We're talking about hundreds and thousands of claims, hundreds and thousands of lawyers. Personal injury is not operated in generalities. It's part of the problem here.
Then for plaintiffs' attorneys to require, suggest, recommend that their clients go see the attorney's preferred doctors and medical professionals. Is that correct?
Would
that be fair?
Yes, that occurs.
Okay. You mentioned a word
Remitter? Am I
Right.
getting that right?
Yes,
Okay, is that a maneuver? Is that a tool that a judge uses?
right.
So, go ahead, ma'am.
So it exists in the appellate procedure, and
Otherwise, to-
right, and I'm under oath, so I have not done that research, but I have seen cases where remitter is suggested even by the Texas Supreme Court in mental language damages. There's a case 2025 out of the 14th Court of Appeals that this award needs to be reduced.
All right, guys, we're kind of skipping ahead here. Want to get to as close to live testimony as we can. I know there's people that are tuning into this just for the audio or commentary portion, so I want to skip ahead to try to keep up with them.
If a judge is going to change the amount awarded in a verdict, it would have to be against the manifest weight of the evidence. But that's what we're talking about. The weight of the evidence, when it is the fictitious bills that no one expects to be paid, is this giant pot of money. And it's very difficult then for a judge in good faith to reduce an award because that was the evidence as it was submitted. And hence the reason for this bill is we're asking for the amount of the bills to be the real amount, the truthful amount, the usual, customary, and reasonable amount. And then there would very unlikely be a very large verdict that's out of proportion with the injuries, right, or the medical care that was rendered, because, and so then, yes, if there becomes a nuclear verdict on a reasonable medical bill submitted, then the judge could absolutely exercise the right for remitter.
So it would be fair to say that that very rarely happens?
Very rarely.
Okay.
And there's also editor. The judge can also increase a verdict, by
Well,
the way.
if I remember correctly, in 2003, I remember that Prop 12, that limited medical mal lawsuit, or it was some tort reform with that. And I remember the term summary judgment for frivolous lawsuits. Would y'all all agree, or let me ask the question, how, are there prevalent frivolous lawsuits being filed? Please.
So
Here we go. Shot in the dark. Here comes a big fat freaking lie. Here comes a lie. She's going to say, yeah, they're all frivolous. That's what they're really arguing, is that every case is frivolous. Every case I can't win is frivolous.
unfortunately, it's very, very difficult to win summary judgment. We call it a dispositive motion, meaning that the judge will take it outside of the purview of a jury to render a verdict, and they will, as a matter of law, say that based on facts or law, there is no lawsuit here, right? I have a case where...
Let's think about that from the judge's perspective. A judge is intentionally allowing cases that are frivolous, which means frivolous means completely fake, completely made up, no rational basis in law and fact. That judges are saying, I know this case is frivolous, but I'm going to waste my time and the taxpayer's time and let it go forward to a jury trial. Trust me, judges hate wasting their own time. Any of the lawyers that are watching this now, comment on how upset judges get when you waste their time. Everybody here will agree with me. There isn't a single judge that can't wait to pour out a frivolous case on summary judgment. It's just a complete fallacy. And let's see the hypothetical she comes up with. God, it's going to be a good one.
The plaintiff committed suicide by jumping in front of a commercial motor vehicle driving down a major highway, traveling at 70 miles an hour. And the coroner investigated this. It was on the news. They even said very clearly on the news that this guy, people had been calling it in, and he jumped in front of the truck. There were tons of brake marks on the road, tire marks, excuse me. The coroner's report then, the manner of death on the death certificate says suicide. My commercial motor vehicle company is still being sued for that, and brought a motion for summary judgment. It's technically pending, but it's been a while. I don't have a ruling. I don't know how hard it would be if that's, I think that's a frivolous lawsuit. It's just very difficult to obtain that kind of judgment. I don't think a judge feels comfortable taking it outside of the jury.
And so I think my point is it fair to say also that summary judgments are very rare,
Yes.
rarely done. So summary judgment's a tool that can be done, very rarely exercised. A remitter to reduce claims is a tool that can be used, very rarely exercised. And I'm sure that we could probably all agree that not 100% of these claims that something.
I do want to make one clarification on the remitter. Right now, if the judge, there's a motion for remitter, the judge can tell the plaintiffs, okay, I don't believe there's evidence to support this portion of the jury's verdict. You can either accept a reduction down to X, or I'm going to grant a new trial, right? The judge does not get to substitute his opinion for the 12 jurors' decisions, right?
Goes back to my point, though, how often is that exercised?
Every time that there's a quote excessive verdict, the defendants should ask for a remediature. They have to. There's no reason not to.
May I? So the reason that it's not used very often is because there is no measure for how the jury should get to non-economic damages. There's no standard by which the legislature or the courts outside of the most recent.
There is. It's called jury instructions. What a complete lie.
Gregory versus Shocare opinion says that, hey, jury, this is exactly.
Shocare, she can't even pronounce the case right. Jesus Christ.
How this is the formula that you use to get to non-economic damage.
Can't even pronounce the greatest defense golden goose in 10 years. She can't pronounce the damn case right.
So requesting a remediature on non-economic damages at the trial court level is basically useless. When it's used is if the plaintiffs come in and they say, hey, past medicals were $100,000, and for some reason the jury writes down $200,000 in the past medical. That clearly isn't supported by the great weight of the evidence, is what the law says. And so the judge will say, hey, go correct that, jury, because you must have seen this wrong. They only asked for 100. The bills are only 100. You can't give them more in the past than what they actually paid or incurred, words we've used a lot today. So you should probably switch that up, or I'm going to give them a new jury trial. So that happens on the economic damage side, but because there's no formula and there's no cap for the non-economic damages, then it doesn't happen on the non-economic damages side. Although the Court of Appeals, it applies differently in the Court of Appeals with the Supreme Court than it does at the trial court level.
Thank you all so much for answering my questions.
Senator Perry, you're recognized.
I appreciate, Mr. Chair. I'll try to be as brief. I'm trying to wrap my head around, and y'all may tell me it doesn't exist. So I have a physician. They're giving you the incurred, which is inflated, and on the back end, they're telling
How is it inflated if it's been paid?
you what they would take. Is that really happening? I mean, Craig, I trust Craig. You're saying it is or isn't happening?
I don't know.
You don't know.
She says it is. I don't do that, so I don't know.
Well, the follow-up, is that not basically fraud? And if an attorney was doing that, knowingly doing that the charge is incurred or paid, it didn't say incurred would be the highest of the bills. It says incurred or paid. So if a doctor's providing some support that I'll take this, but this is what you should ask for, and then I'll sign an affidavit that that's what it really should be, market value, would that not be some type?
I don't even understand this hypothetical. Comment in the chat if you follow this guy. I don't know what he's talking about. Is he saying a bill that's still owed, and I misstated incurred? You have a bill that's incurred and they've went and had the treatment that hasn't been paid yet, it's still due, but then is overinflated. What?
Type of fraud in its inception? I mean, to me, you can't be an unfair dealer in this conversation, but we're told it's happening. You're saying you don't know, but somebody's doing it or it wouldn't be part of the conversation.
Yeah, I think.
Because it's part of the conversation because the insurance companies are making shit up. Hey, you know what? The sky is blue. Okay, now that's part of the conversation. Let's just say things.
There are people coming behind us that can answer that question of how that operates, because I think we have some providers who work on a letter of protection. They can tell you how it works.
Let me back up. Just 10,000 foot view, would that be fraudulent if you're getting two different amounts for the same services?
I don't know if it's fraudulent or not because I don't know the circumstances. For example, if
it's not fraudulent if two private businesses charge different amounts. That's called capitalism. Isn't that what you Republicans are all obsessed with and say will cure all is capitalism?
he says, okay, I'm gonna charge you $10,000 for this, but if you're not gonna get much for the case, come back and we'll talk, and I can do it for less if I have to. I do that all the time. I sign up a client on 33 1/3%, but if it turns out that I need to reduce my fees in order for them to accept a settlement, I say, yeah. And I go to providers all the time, especially like you do it with insurance companies, health insurance companies that file a lien, and they file a lien for the entire amount of the bill that they have paid. But when it comes time to go to mediation, or even if you get a judgment, you go to them and say, hey, you got a $100,000 lien on this case, but we only got $200,000, whether it's by settlement or verdict. And I negotiate with health insurance companies all the time under that circumstance. So is that fraud?
Yeah, but I think you make my point for me. We're not asking what we're going to negotiate from, and we're not asking that you should start with a higher amount so that whatever you're willing to take is a lesser amount. We're asking what is the actual cost of those services, and that goes to an
We don't know. We don't know either.
objective database to tie that to.
Yeah.
And an objective
The database that doesn't exist yet, let's not forget that, and the database won't tell us that either.
database that represents what was actually paid across the board and not what was billed, because the medical practices of today, and THA and these people will disagree, is built around a bogus chart that's been around for the dark ages called master billing. But I found out today that that's not even a standard that is used. It's whatever the medical professional decides, hey, ask for $100,000. It really probably only going to cost me about $10,000, but you can get a bigger settlement if we inflate it on the front end. So you make my point. If your perspective is we got to start here because we can have more to negotiate, that's not what the fair settlement should look like. It should be what it costs for that person to get the medical treatment and compensatory damages in a loss of wages and those things. It should be very much. I can agree that there is a subjective piece of this, but I also know how much someone was worth if their college background was this and they're in this profession and they can no longer fulfill it. Those are
looking up old Charles Perry's background right now. He's from Lubbock. I like that. Love people from Lubbock. Went to Texas Tech, certified public accountant. Let's see who he's taking money from.
things that you can kind of get to. But what I heard you say, and I don't mean it's a bad thing, what I heard you say is, I negotiate down based on what they're going to pay me. And to the opposite, it's not you shouldn't be negotiating down to what you can get paid on. It should be, what does it cost to do this healthcare, period. And it should be what was paid and not billed, because that's the game the insurance companies and the hospitals and the medical profession. When we talk about runaway inflation in Medicare, which is averaging around 8% for the last 10 years per year, highest inflationary cost we have, and you look at it, and it's all built around these master billing charts that don't reflect actual cost.
He's true on that. And that is true. That is true.
And nobody wants to tell us what actual cost is. You ask a hospital, what's your cost of delivery of care? You ain't.
Right. And we don't get that information either. We don't get the contract rates. And this bill doesn't address that either. Why is that not discoverable from us? How do we know? And I actually see it all the time where the hospital will assert massive charges that are nowhere in line at all with those in the community. Why? Because they want to get paid. They want to take advantage.
You're going to get it. Promise you. Because how their cost accounting is and what I learned in school is cost accounting, no relevance to reality.
I would also point out, Senator, that if I don't have health insurance and I go to a doctor's office and say, can I get the Blue Cross Blue Shield rate? The answer is no, right?
What most providers do, not all, and we've got legislation to this session or in prior sessions, there are some that take health insurance that cannot take a cash payment if you have both. So that tells you the game in that conversation. But secondly, typically, providers have a discounted rate for cash payers, private payers. So it's never usually the opposite end where it goes up. So I understand that, but that's apples and oranges comparison of it. What is the real cost? Does the jury have the information to determine what?
So y'all please be ready to testify as soon as we hear from this panel. Welcome. Introduce yourself. Give us your testimony.
There's my old roommate. That was my old roommate there. Old Andrew. Looking good. Looking healthy, my man. Great dude. I'm going to have to call Andrew, see why he's in the state Senate. Not a legislator, but a good dude, very smart lawyer.
From this panel. Welcome. Introduce yourself. Give us your testimony.
Yeah. So good afternoon, Chairman
Will Adams. Shout out to Will Adams. Awesome dude.
Schwartner, Vice Chair Perry, and distinguished members of the committee. My name is Duke Austin, and I am President and CEO of Quanta Services. I am pleased to testify in support of Senate Bill 30. Quanta Services is a Fortune 200 company, proudly headquartered in Houston. We provide infrastructure solutions to the electric power, industrial, and communications sectors. We have over 60,000 permanent employees across North America, including over 15,000 in Texas. We have invested millions of dollars in our advanced training center in LaGrange, Texas, where we have provided training to over 80,000 craft-skilled workers, Our men and women in the field are the first responders to repair and restore after major storms. Excessive litigation poses significant challenges to our business operations and overall growth. In the last 10 years, our insurance costs have increased 5 times, and our deductible is up 10 times. The financial burden drains our resources and diverts our funds away from essential investments in infrastructure, training, and emergency response. Litigation also disrupts our daily operations and takes valuable time away from our primary responsibilities. We have been direct.
So why don't you go call your insurance company? Why don't you say, how are you reporting record profits? Let's look at your financial statements. Why are you raising prices arbitrarily? Which this bill doesn't mention. If the bill was truly about lowering insurance premiums, if it was really about that, the word insurance would be mentioned in the bill, and it's not.
In many cases, we've seen the actual cost in insurance in states specifically.
I don't care what this guy has to say. He's another corporate shill.
Support protecting Texas.
Thank you for your testimony. Thanks for being here. Mr. Adams, welcome. Introduce
Here we go. Here's a good one. This will be good. Here we go. Let's hear from Will.
yourself and go ahead.
Thank you, Chairman. My name is Will Adams. I'm a former president of the Texas Trial Lawyers Association, and I'm here in opposition to the bill. It's an honor to appear in front of this committee, and frankly, an honor to appear next to Mr. Austin. Mr. Austin and I got to know each other a long time ago when he was a Sigma Chi at Sam Houston State University, and I would visit my friends there. And we recently reconnected, and oddly reconnected for a second time as we ran into each other over on the sidewall. So it's good to see him. He runs a good company. My president, Jack Walker, asked me to speak on a very specific portion of this bill, and that is the medical bills portion. It's been discussed a lot today already. I've been listening to the questions and the comments, and I want to be as direct to those as I possibly can. There's been a lot of talk about lying and cheating and fraud and that sort of thing. My personal experience is different, not just in my practice, but with my colleagues and my friends who are in the association with me. So it's not my experience. It sounds to me like what we're trying to do is legislate towards that fraud, which I get wanting to do. The problem is when you try to legislate the bad apples, you are sweeping in the rest of the bunch with that. And
while claiming fraud with no evidence of fraud. How come these people haven't been arrested if it's fraud? How come the 2 defense lawyers we saw from haven't testified to the DA or brought fraud charges?
I want to talk about that today specifically, and how this bill would impact cases and injured Texans who do not fall under that accusation in any form or fashion. So the way the bill works quickly in 4104A1 and 2, if the injured victim has the means to pay for their own bills, they get those recovered. If someone pays them on their behalf third party or not, they get those recovered. What this bill impacts the most are those who cannot pay their own bills, do not have their own health insurance. And so what this does, and I want to be clear, this does cap medical bills that can be recovered. 4104A, it says the economic damages that may be awarded for healthcare services are limited. And then it sets forth those 1, 2, and 3. The third one is the major concern, obviously. It's the 150% multiplier on what I understand at this point is going to be workers' comp. So, two, what I believe are unintended consequences of that provision and how it will impact cases that I think we all would agree don't fall into that accusation. So, picture this. A young woman is in a terrible crash. She fractures her hip terribly. She doesn't have health insurance. A surgeon agrees to operate on her and afterwards sends a bill for what is the range of either what private insurance would pay or the cash pay rate, which from what we've been able to determine is between $10,000 and $20,000. That woman is forced to file a lawsuit on that between $10,000 to $20,000 bill. Why? Because with this law being in effect, the auto insurance company for the responsible party is only going to pay what's under 41-104-3, which is 150% of the. It's what.
Listening to Will Adams right here. Thanks everybody for tuning in and following along. I hope you're finding this enjoyable. Will is focusing here extensively on the medical bills portion and what is recovery, arguing that it really is capped by the 150% mark in the bill.
It doesn't cap the bill. It caps the recovery at trial. The bill remains. So a lawsuit's filed because the auto insurance company does not want to pay the $10,000 to $20,000 bill because why would they? This bill says that all this young lady's going to get at trial is the $4,000. I disagree with the witness who said that this will decrease the backlog. This will increase the backlog of cases for this very reason. May I wrap?
Go ahead, thanks.
The one thing that we should all want to do is avoid shifting the harm back to the injured victim who was injured through no fault of their own. The only people that that is good for is the wrongdoer and their insurance company. Thank you, Mr. Chairman, committee.
And thank you for your testimony.
Oh, we got Mike T back in the chat with Bad Law Worse Facts. I hope you had a chance to go subscribe to his YouTube channel. Will Adams is the man. Couldn't agree more.
Senators, is there any questions for Mr. Austin, Mr. Adams? Dean Safrani, you have the panel.
Thank you, Mr. Chairman. Mr. Adams, you said that this bill would increase the backlog. In what way, sir?
So in the situation where you've got to be clear, under 1 and 2, if you're recovering what you paid or what somebody paid on your behalf, I don't think it's going to change it at all. Under 3, where you've got the uninsured or the folks who can't use it for whatever reason, high deductible premium or whatever, the bill will be larger than 150% of comp. It will be, probably significantly. And so if all the auto insurance company believes that the injured victim will be able to recover is 150 of comp, well, the only way to attempt to get more money, maybe in other areas to be able to pay that bill, is to go to trial. The other areas that we've talked about with other witnesses, pain and suffering, mental anguish, otherwise the bill sits. So you've got a injured party, injured through no fault of their own, who either has to come up with the balance or the doctor has to decide to not pursue it. But that also puts the doctors in the position of deciding whether or not they're going to pursue it. And sometimes they're going to do that up front, which creates another problem in this bill is patient access to care. The sad reality is the pool.
A good point by Mike in the chat. You think insurance is going to pay that even? No, they won't. No, why would that?
Pool of doctors willing to see, for example, car wreck victims is already small. I know this in my practice, and I practice in cont'd, which is a conservative, middle to upper class, health insurance covered community for the most part. There are treating doctors who will not see them, even if they have health insurance, because they don't want to be involved, which I get. But to answer your question, I think I went a little far afield. They're going to be forced to. They're going to be forced to file a lawsuit because they aren't going to be able to pay the bill unless they do and take it to trial.
Thank you. Sir, you also referenced unintended consequences. Could you expand on that, please?
Sure. Well, I believe in my heart it is not an intended consequence that what we just described, that someone who was injured through no fault of their own is saddled with a medical bill that they didn't want, or a balance of a medical bill that they didn't want. I think that's an unintended consequence that is necessarily going to happen, even in cases, for example, set aside what I believe are outliers, set aside whatever it is, $100,000 visit to the doctor, because that's what the doctor says it's worth. And let's look at what doctors charge for cash pay. The disparity between that and 150% of comp will end up with the patient holding the bag or the doctor pursuing collection. I don't think that's an intended consequence, but it's going to be a consequence. That's what I meant by unintended consequence.
Thank you. Did I hear you correctly say this bill doesn't cap the bill, it caps the recovery?
That's correct.
Thank you. Thank you, Mr. Chairman.
If I may respond, I would
please
say in practicality, when you're trying to acquire insurance and they won't insure you because of the way that things are litigated today in Harris County or any other state in Texas.
Then get a new insurance company. Isn't that the whole point of capitalism?
Over 300. My family was a family business. And so yes, there's good and bad actors, I agree, but the intentions may be good or bad, but the facts are the facts. And
the fact is this bill does nothing for your insurance premiums, dude. They're going to keep them the exact same. They're going to keep going up because there's nothing in the bill that requires them to lower insurance bills or lower your insurance premiums. They won't insure you because you suck at driving. Great point by my boy Mike in the chat.
Today, insurance, you either become uninsurable or the costs rise so much it's very difficult to stay in business. And not just workman's comp, it's auto. And on the face of it, when someone's coming from Cook County, Illinois, or Los Angeles, California, to try in Harris County, fundamentally, we have an issue here in the state.
And thank you both for your testimony. Members, any other questions for either of our witnesses, Mr. Ross or Mr. Adams? Thank you both for being here. Thank you very much.
Thank you, Chairman.
Mr. Chairman, as you bring up the first group of individuals, I just wanted to mention to the senators, y'all have been very attentive, as y'all always are, and if there's ideas that your staff, people you know, I would, as the author, I would certainly appreciate the work of the committee, really. And we do this a lot in B&C, ideas or thoughts about how to work the bill, suggest changes, et cetera. So I just want to make sure y'all all heard that directly from me. Thank you.
And thank you, too.
Yeah, they're not coming because they're good attorneys. Trust me, they're coming because the verdicts are better in California. Yeah. That's right.
Senator Perry.
I'd just say, Chairman Swartner, I think the last witness made a pretty critical distinction that if you're private pay, non-insured, and a doctor does good faith surgery in that example, that if it falls within that 150 of the range, that, but the actual costs are supported because that's what in that case, a hip surgery needed to rehab that person back, that maybe you can do some type of the lesser of or the greater of, as long as it falls within that reasonable comp, because in that situation, what I understand is the person's going to get a $4,100 check to pay a $20,000 bill, but probably $20,000 is not unreasonable. So some way, Mike can look into that, but that I don't, kind of goes to what.
So they're stuck paying a $20,000 bill instead of a $40,000 bill with a $2,000 settlement check. That's your hypothetical. You know who's going to end up paying that bill? We are, taxpayers. That's who pays the bill. Chairman
Hughes was asking today. The private pay keeps coming up. It's a recurring theme for private pay for because you don't have the uninsured, not the private pay, but the non-insured. How is that delta of what the chart does and what an actual cost of reasonable care that was provided? How does that work? So I think that was pretty telling in that perspective. So.
We've seen this obviously in other settings, the surprise billing in hospitals and being the non-providers of a network, and then you go in, you have a bill, and you're not on network, right? Whether it's freestanding ER or hospital, and so you get charged the delta of the amount, and so it's a real issue at times that this is in reference in this case of an individual without any health care coverage being billed a certain amount and their potential settlement amount with an insurance company outside of litigation is a lot less than the billed amount. So I understand your concern, Senator.
And thank you, Senators. We'll now open public testimony, and I'll call the panel that I had previously announced. The Chair calls Honorable Jim Wright, Charla Aldous, Joseph Montgomery.
Oh, Charla's going to testify. Here we go.
Cheryl Welsh. Four witnesses, Arza, those that over here close to them.
An individual, as a small business owner, is 35 miles per hour. Operating property is equipped with cameras, and one of the cameras is positioned to watch traffic along the highway, frontage, and the operations entrance. Although I was not physically at the property when this particular incident occurred, I was able to view the camera, which clearly showed this particular event. In
My water, to refill my soda. I will be right back after a short break. I'll keep the stream going. There we go.
But as the camera showed, I could stop if you need me to.
You go ahead and finish that thought, Commissioner. Go ahead.
My driver failed to come to a complete stop before entering the roadway, but as the camera showed, he apparently did not notice traffic coming down the road and stopped halfway out in the first of the two-lane highway. The camera showed a work truck approaching at a speed according to camera calculations above the posted speed limit. It was obvious in reviewing the camera's footage that the driver of this work vehicle actually did notice the truck, and there was an apparent attempt to go over to the other lane, but then suddenly turned back, just scraping the front of my vehicle. When stopped approximately some 20-30 feet beyond the position of my commercial vehicle, 3 of the 4 occupants exited, sat and laid in the highway at the front of the vehicle, which was still located on the roadway, and an ambulance was called, and all 4 work truck occupants were transported to a local hospital. When I was made aware of this incident by my safety officer, I was told 3 of the occupants had no form of IDs and were apparently not legal citizens, and the 4th was a citizen and owned the concrete construction company the work truck belonged to. My safety officer stated in his report he had not observed any sort of major physical injuries from any of the occupants of the work vehicle. The incident was reported to my company's insurance carrier, and I asked my corporate attorney if a person not legally residing in our country could bring suit claiming personal injury. He informed me they can and they will be allowed to remain within this country until a decision and a legal claim is made. The result of this incident was a mediation settlement made by my insurance carrier's attorney, and where the driver owner of the concrete construction company received $3.5 million, and each occupant $1.5 million, which was the maximum amount coverage that my company had at that particular time. This is why commercial insurance cost is becoming a cost few small businesses like mine can afford. Today, with the escalating cost of insurance, we only insure equipment that is 100% utilized and parked at the rest. This has resulted in revenues way less than what my company has the ability to do. My workforce in recent years has had to be decreased by 60%. It is my hope this bill will cut down made-up claims amounts like the ones I just described. I hope it will make trials and mediations more fair to produce honest results. I hope it will help reduce the cost of insurance because right now the cost of insurance is about to drive me out of business. Thank you for allowing me to present this testimony to you, and I'll take any questions afterwards.
Thank you, Commissioner. Welcome. Introduce yourself and give us your testimony.
Thank you, Mr. Chair. I'm members of the board. My name is Joseph Montgomery. I'm a safety supervisor for coastal transport out of San Antonio, Texas. I'm also a former driver of the company. As a professional driver for the past 27 years, I've seen my share of accidents. I was involved in one outside of Houston about 5:30 one morning. It was raining. The lady hit some water, hydroplane, and she ran into me. I did not hit her. I got out of the truck, had a conversation with her, asked if she was okay. She said she was fine. I asked her, did she need an ambulance or a doctor? She said, no, we just called the police. Police arrived on the scene. All of a sudden, she didn't speak English anymore. So, got to the company. About 2 hours later, her attorney was calling the company following the lawsuit. Her attorney had not seen the video in our trucks, and we do have cameras in our trucks. Once her attorney saw the video, he dropped the case. They didn't see the video. All they saw was dollar signs because they saw this big truck, and they heard truck accident and automatically assumed that I was at fault. There has got to be checks and balances, and that's why I'm here to support SB 30. We just can't allow
This bill has nothing.
attorney
This bill doesn't address any of the things that truck driver's talking about.
system and just do whatever they want to do. Now, people do need to be compensated if they're legitimately injured. I have no problem with that. But I do have a problem with nuclear verdicts that put companies like this man here out of business, or smaller companies that inflate, that have to pay more for insurance because of a verdict. It's difficult to trust the system when you're told that a system is not working. It's difficult to go to an attorney and they tell you, well, this is between you and I, or under the table. I yield. Thank you. I'll answer any questions later.
This is under the table. This is between you and I. What?
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good evening. My name is Carol Welsh. I am a victim of a 18-wheeler wreck right outside the building on I-35 here. I was moving from Virginia to San Antonio, not even here yet, coming to close on my house, and the truck came from the left-hand lane, the far left. He was not on my tail, didn't brake or anything, and slammed into my car. And I have had 14 back and neck surgeries.
14 surgeries.
Since that time. My cervical is fused 4 levels, my mid-back is fused 4, my lower back's fused, my
Talk about pain and suffering. This lady's got it.
SI joints are fused. I had several nerve, I had brachial plexus on both sides, nerve surgery, and I had several nerve, and it's just basically ruined my life. I am a victim and a survivor of this thing, but I wouldn't want to wish it on anybody, regardless of payments, no payments, whatever. It's a horrible thing to get in that situation, especially I was moving from Virginia.
Great point by Mike here. 14 surgeries, insurance companies, only a scratch. That's exactly what they'll do. They'll say her 14 surgeries are worth $250,000 or less, and unless you have a unanimous jury, you get nothing.
Virginia to here, I didn't know a soul, I didn't have a doctor, I didn't have anything. And I ended up in Austin, and they x-rayed me, or CT scan, said you didn't break anything, you go home. I didn't have a home. So it was in the process of being finished built. So the whole process was very bad. It's ruined my life. I'm a nurse. I was planning on working when I got here, when I got settled. I could not take a job or even volunteer because I'm unreliable. I have good days and bad days. And so I can't sign up for doing a job, with pay or without pay for volunteering like at church or something, because I don't know if I would ever be able to meet the obligation that I committed to. So basically, I stay at home most of the time. I drive to the H-E-B and Costco, and that's it. I sit at home most of the time, and what I really think about this bill is to really, really think about it and what it be doing for other Texans that are or even other travelers through the state that would have a similar accident that, just all of a sudden ruined your day, life, basically. So anyways, for the others.
Thank you for your testimony. Welcome. Introduce yourself and get close to the microphone and give us your testimony.
My name is Bita Shakiba, and I'm
just a second, Ms.
Hold on, I missed what she said.
Thank you for your testimony.
Just all of a sudden ruined your day, life, basically. So anyways, for the others.
Thank you for your testimony. Welcome. Introduce yourself and get close to the microphone and give us your testimony.
my name is Bita Shakiba, and I'm
just a second, Ms. Wells. We may have questions for you, so that's okay. I'm sorry, that's okay. No problem. You're not in custody, but we may have questions for you if you want to stick around for a few minutes. Welcome. Introduce yourself and go ahead, please.
My name is Bita Shakiba, and I'm a root canal specialist. I only do root canals. I got sued frivolously. I saw a patient. I did a root canal. I numbed the patient. My needle was 21 millimeters. I got sued a month. I got a letter, and I got sued a year later that my small needle perforated the mouth and went inside the orbital globe and perforated the orbital globe. Now, the expert witness and the plaintiff's lawyer, they are in the same street. They know each other for sure because they're practicing the same place. And
if you're on the same street as a doctor and you practice as a plaintiff's lawyer, you have to know that doctor.
And it has been like 2.5 years that I've been running in circles. I'm telling people this is a frivolous case. Anatomically, based on human skull, this can't happen, but it has happened. My lawyer, who my practice insurance gave me, we don't still have the plaintiff's medical history. We don't have any information about the plaintiff, and the whole process has taken time.
It sounds like you got a shitty lawyer.
For me to treat my patients. I don't know, do you guys want your doctors to have these frivolous lawsuits? Because you can't focus when you're dealing with this. So many hours of my time, my precious time with my kid, my precious time with my patients have been lost due to this lawsuit.
Oh, Hatch is back. Let's go. Hatch, Mike Tackle, Adam Holden, Tapperman E.T. Adam, they have questions for her because she was the victim of a truck wreck. I'm not sure. She didn't state a position on the bill, but I'm not sure what they're going to ask her.
And yes, all the medical records have to be taken because if a patient has syphilis, which is a sexually transmitted disease, they might have hearing loss. So yes, we have to get all the medical reports. And then the other thing is transparency. We have to know if our doctor, who is my witness, which is the expert witness, knows the lawyer. If they know each other, then this is where everything happens. Thank you.
Thank you, doctor. Thanks for your testimony. Welcome. Now, since you're on the end, you got to get close to the microphone. Introduce yourself and go ahead.
Yes, my name is Charla Aldous, and I am a lawyer.
Here we go. Hell yes.
Here in Texas. I've been practicing for 40 years. While I am a member of TTLA, I am not here speaking on behalf of that organization. I'm coming here today to speak on behalf of a very distinct part of our population who will be devastated by this bill, and that is survivors of sexual abuse. I have never said this in a public forum before today, but I'm doing it now. I know their injuries because I am a survivor of childhood sexual abuse. And when I listened to Ms. Fitzpatrick, Senator Paxton, with your bill 2420, my heart was broken. She talked about grooming. I wish I could sit down and tell you about the cases that I see on a daily basis. And I wish I could tell you about the threat of having to pay high damages effectuates change. In the interest of time, I'm going to give you one small example, but I've got I have a small firm. My daughter practices with me. I have one other lawyer. I've got 5 cases right now that if I could show you what's happened to these children, these girls, and show you what this law is going to do to them, I can't tell you how I'm pleading with you not to include sexual assault victims in this bill. I wish I could talk about other parts of the bill because there's so many things that concern me. I had a little girl that went to a private school about 12 years ago, and she was groomed by a teacher.
Powerful words. Powerful words.
She was around 13, groomed by a teacher for months and months. We had the evidence, and I didn't even understand the extent of it. She was groomed by that teacher who sexually abused her for over a period of months. The school found out about the sexual abuse. This little girl had gone to this school since she was in kindergarten. Her 3 older siblings had gone to the school their entire life. It was this family's entire community. What the school did when they found out about, may I continue?
Yeah, go ahead and finish the thought. Yes, ma'am.
Okay. When the school found out about the sexual abuse, they allowed the teacher to resign. They brought my client's father into their office and said, we know what happened. We don't want this taint on our school. You can withdraw your daughter or we will expel her, and there is no door number 3. They wrote that in an email. Another email revealed that they said they did not want this girl haunting their hallways with her sad, sad story. These parents had to come home and tell this little girl she could no longer return to the school she had gone to her whole life. She was suicidal when I started representing her, but I told her I would give her a voice. This school wanted to pay money. Their insurance company wanted to pay money. I said, no, you're going to make policy changes. Because there were policies that were allowed in that school that allowed red flag after red flag after red flag to take place to allow this grooming to take place and this child to be abused. Well, I went and tried this case, and I'm usually not afraid in court, but I was scared to death. And the reason I was scared to death is because this child's teacher had betrayed her. Her school had betrayed her, and all the studies show that secondary victimization is worse than the actual assault. And I thought, God, what am I going to do if this jury betrays her? But the jury didn't. The jury awarded a verdict, and they awarded a verdict for millions of dollars, which I had never expected. But guess what? As in so many of my cases, after this verdict was awarded, the school and their carrier came and sat down, and they said, okay, we'll make the changes. Significant.
Thank you. See, they won't change until you make them change. They have no incentive to change without a verdict. They're not going to have any incentive to change with a $250,000 verdict. Why would they? It's the cost of doing business.
Significant changes that will save children in the future. And we took so much less than what the jury awarded. But I can tell you case after case, I'm sorry, I'm very passionate about this, that would show you, I've got a rideshare situation right now. Can I keep going?
I think there's going to be questions as well. And Senator Schwertner had.
This is the problem. We give people 5 minutes to testify on a bill that will change hundreds and hundreds of thousands of people's lives. Legislature is such a joke.
Yes, and then we'll have Dean Zafrani after that. Senator Schwertner, you're recognized.
Thank you, Mr. Chairman. The adjudication of sexual abuse cases, are they done through Chapter 41 of the Civil Practices and Remedies?
I'm sorry, I can't understand you.
Are sexual abuse cases adjudicated through Chapter 41
Yes.
of the Civil Practices
Yes.
and Remedies Act? They are.
Yes.
Okay. That's what I wanted to know. Thank you.
Well, let me get an Altoid real quick. Are they done through Chapter 41? This dude doesn't even. Jesus Christ! This is making these are the people making the laws. Jesus.
Can we talk now?
Well, I think Dean Zafrani has a question as well. Dean, go ahead.
Thank you, Mr. Chairman. Ma'am, that's a horrific example that you gave us. But looking at this bill specifically, how would you amend the bill to address cases like yours and to ensure that they are not repeated?
Well, let me tell you, first of all, I am speaking on behalf of sexual abuse victims, but I take issue with a lot of what I've heard from some of the defense lawyers. I did defense work for many, many years. I still represent a lot of physicians. I have a small practice, but I'm telling you, they talk about nuclear verdicts. And this ties into the sexual assault victims. Every case, and I've had some really, really big verdicts, but every one of those cases, they did not give me a fair offer. When somebody said insurance companies are fair and reasonable, I can tell you in my experience over 40 years, some of them, yes. A good majority of them, no. Most of the nuclear verdicts that I have gotten, I got one last 6 months ago for $74 million. We would have settled for a fraction of that, But they said no.
But they said no because they don't need to make a fair offer. They're not going to make fair offers when there's no penalties for not doing so.
Now I'm asking for a remediature because our Texas Supreme Court is taking care of these nuclear verdicts. They are.
Thank you. Charles makes a great point here. They act like the insurance industry acts like there's no remedy for them to fix these nuclear verdicts. It's the Texas Supreme Court. It's the insurance company's wet dream. The most corrupt, most pro-industry, most pro-pharma, big pharma, most pro-oil and gas, big corporate Supreme Court. They couldn't have put together a better Supreme Court in a science lab for the oligarchs. This Texas Supreme Court has never upheld a plaintiff's verdict in 25 years. If they have, drop it in the chat. It'd be the very first one I've ever read. They've never done it, ever. That's their adequate remedy on appeal. That is why none of these nuclear verdicts are paid. They're not, because they go to the Supreme Court, the Texas Supreme Court, where it takes nearly a decade to get there, and then they reverse and render, and everyone gets nothing.
I'm asking for a remediature in that case to lower the amount to a reasonable amount so that my clients can be compensated. But for that quote unquote nuclear verdict, it would have never happened. You hear these things about what's going on and what's wrong, but I want to tell you, these nuclear verdicts that they say are nuclear are being handled by the Court of Appeals. But what you're doing, and with I've got a case where a rideshare case, where she was a dentist in Dallas, went out for a drink with a friend. The rideshare company picked her up with her friend, took her friend to her apartment. She was in the car. He said, "You're going the wrong way." He said, "Well, let me see your phone." She handed him her phone. He pulled out a gun and said, "I'm going to kill you if you don't stop and pull over to this field." He violently raped her in the back of that seat. I find through discovery that 10 days before this woman was picked up by that Lyft rideshare driver, 2 different women had complained to the rideshare company about sexual advances this very driver had made.
But ma'am,
those safety calls are outsourced to Guatemala.
But my question, ma'am, is about, you said specifically, I wrote it down, survivors of sexual abuse will be devastated by this bill. Chairman Schwartner has invited the members of this committee to work with him in developing this bill. You could tell, I hope, by my questions that I have serious concerns about this legislation. What I want to know from you is specifically how would you amend this bill to address this issue? I know you have many, many cases to share with us, but we need to work on this bill. How would you amend it?
I can tell you this.
You don't need the bill. You don't need the bill. Are you not listening to anybody? Because you don't want to listen, because you're bought and paid for. You don't need the bill.
The caps need to be taken out. And they say they're not caps. They are caps. If we have caps on our damages, it takes away our big stick to effectuate change. And I know there's a lot of the bad stories that you've heard, but you got to understand there is some good work being done. And we can say you have got to make policy changes or this is what you're facing. And then after we get a nuclear verdict, we can use that verdict to effectuate the policy changes. Does that answer your question? I'm trying to.
Not quite, but maybe you can look at the bill and get back to us. But thank you.
I would love to. Can I say one more thing?
I think there may be more questions. Senator Paxton had questions as well, so I'll recognize her at this time.
Thank you. I wanted to clarify, make sure I heard you correctly. I think what you said was that the nuclear verdict came after there was no willingness to settle for something. Is that correct? So you try to settle, and that would be your preference, and you're willing to settle for much, much less, and there's...
And Senator Paxton, I can't tell you the number of times that has happened to me. Time and time again, we demand what we think is a fair compensation,